Good morning, and thank you so much again for letting me be part of your series on small business protections. And today we're going to be talking about copyright, which is a form of brand protection, but it protects more than just your brands. It protects artistic works that you create through your business. So let's just launch right in. What is copyright? A lot of people hear the term and they don't know what it is. The definition of a copyright is an original work of authorship fixed in a tangible medium of expression. What that means is you have to actually create it. You can't just think it. It can't just be an idea. It has to be something that's fixed and tangible to be protected. Copyright exists upon creation of a work, but you cannot sue an infringer if you don't have a registration for it. And we'll be talking a lot about that kind of thing today. Ideas are not protectable. Oh, I have a great idea. I tell somebody about it. Well, you just lost your rights to it because you told somebody about it without protecting it. Things that are in the public domain are not protectable by copyright. And this is useful if you're thinking about using something that you're trying to put into your business that you've seen somewhere else. What kind of works get copyright protection? There are literary works, a book, a written speech, your advertising, your website, source code, musical works, sound recordings, dramatic works, pantomimes, choreographic works, and remember, written choreographic works, sculptural works, other artistic works such as paintings and photographs, motion pictures, and audiovisual works. There's something called a mask work that is also protected that I won't be talking much about today because it's fairly specialized type of copyright work. The person who creates the artistic work is the owner of that work. The author has the exclusive right to reproduce, make derivative works from that work, distribute copies of the work, transfer the work, or perform it. A derivative work is something that is adapted from the original. We often get confused between the copyright in a work, the ownership of the copyright, and the ownership of a physical item of the work. If I create a sculpture and sell it to Laura, and Laura then loves this work and decides, I want to put it in my house and show it, she can do that. She can sell it to someone else, but she can't take photographs, make postcards, and sell those postcards. Because she owns the physical thing, she can keep it or sell it. She can't commercialize it. If I am an employee and I create a work for my employer, the employer owns it. If I'm an independent contractor, I am the author and I own that work unless I have a contract with someone else to assign that work to them. Some people call this a work for hire, but a work for hire is a very narrow set of classes of goods that are created, such as a contribution to another work. So if you're ever trying to create a contract with an independent contractor to make sure you own any work that contractor creates, make sure you officially call it out as an assignment of rights. Now, the author has a lot of rights, but those rights are limited. Other people may use the work for fair purposes, such as reporting, criticism, comment, teaching, scholarship, research, parody, satire, First Amendment, or in some cases, public policy. In order to determine whether use is fair, we look at whether it's for commercial purposes, how much of the original work is used, is there an effect on the potential market for the original work, and is that new work transformative? Now, I'm going to tell you right now, it's a very complicated process. and consult with an attorney if you're thinking about using somebody else's copyrighted work for any purpose at all. Computer programs have a little bit of an odd fair use. Most people need to create a backup, or they actually write computer software onto their computer in order to use it. Those copying procedures are considered fair use. Copyright exists for both published and unpublished works. And by that, I mean, have you distributed your work to other people? That's the easiest way to think of publication. If you are offering to distribute, in other words, advertising, that's not publishing. And if you just display something, hang a work in a museum, or you perform a work, such as a choreographic work, that is not publication. In some instances, a website and all of the verbiage and artwork on a website might not be considered publication. It might be an unpublished work. It would depend whether your terms of use state that you may not download anything from the website. Again, if you have issues about whether something is published or unpublished, it's best to speak with an attorney, because your protection and the timeline of your duration of protection depends on whether that work is published or unpublished. Any copyrighted work published before March 1st, 1989 requires a copyright notice on it. And I've put a little copyright notice here so you can see what it looks like. It's the letter C, or the word copyright, the year of publication, or if it's an unpublished work, the word unpublished, the name of the owner, and all rights reserved. Any of those earlier published works that did not have a copyright notice were considered in the public domain. That copyright notice is no longer required in order to protect your copyright, but it is recommended. A willful infringer has a much tougher time proving innocent infringement if you have a copyright notice on your works. Now, in our last talk, we talked about trademarks being protected for the whole time you use the mark, and patents are protected for 20 years, plus or minus. The duration of copyright is quite long, so it's worth considering in the group of protections that you consider for your brands. If you're an individual, copyright subsists for your life plus 70 years. If you're a company, or the work was created for a company, copyright survives for 120 years from creation, or 95 years from publication, whichever's earlier. There are a lot of different duration periods. They're very complicated, and I will refer you to the Cornell website that I've listed on this slide so that you could take a look at those, at a huge table that talks about all the years and whether works are in the public domain or not. In general, if you are using a work published before 1925, it's in the public domain. Any work that's prepared by the US government, including its employees, is considered public domain as well. And that's why you'll see me sending out copies of government circulars, because anyone can make copies of those documents. Once the duration of copyright ends, the work is in the public domain and there's no renewal period. Now, the big key here is registration. For a lot of reasons, you need to register your copyright in order to protect it. This can be done through the US Copyright Office, and this is a division of the Library of Congress. You would go to that website, click register, create an account, follow the instructions, and you may wish to consult with legal counsel before you file your first application. You may also consult a giant compendium that the Copyright Office puts together for its examiners. It is probably 6 inches tall if you printed it out, and it is chapters 100 through 2400 with many, many subsections, but it is fairly easy to search, and it can be viewed from the copyright.gov main website. The application itself is fairly straightforward, and I'm going to go through the kinds of things that you need to include and have before you start filling it out. The first thing you need to know is the type of work, and this is something you can't change later. So if you put literary work and you later think, oh, it really is an audiovisual work, or this is a visual sculptural work, you have to start all over again. You can't edit this application once you pick type of work. From there, everything else is editable. The next item you need is a title for your work. If you think there's going to be a lot of edits and changes over years and you plan on filing multiple applications, make sure you put the year in your title so that you will easily be able to find which work is registered. You will next need a date of creation, and that is the date you actually affixed the artistic expression into a tangible medium, not the date you first thought of it. You will also need a date of publication. When did you first distribute it to the public? If you didn't distribute it, you're going to say it's an unpublished work. You will next need a list of all the authors and a name of who is claiming ownership of the work. You will need a contact so that if someone out in the world wants to ask you for permission to reuse a portion of your work, they know who to contact. You also need a contact for correspondence from the US Copyright Office. And if you have special handling needs, you'll need to explain that. The only time you have special handling is if you are in the midst of trying to stop infringement and need a very fast turnaround on your registration. And then you'll need a deposit. The deposit is your actual artwork or the best copy of it. For example, you can't send in a sculptural work, so you'll send in a photo of that sculptural work. And then make sure you include a copyright notice on your deposit. So it's not very expensive to protect your copyright, and it's fortunate because in this instance, it's not like trademarks where you have common law rights to go after infringers. Here, unless you register, you cannot sue someone. So if you are a person and not a company and have a single work and it is the claimant and the author are identical, the cost is only $45. All other applications are generally under $100 unless you need that hurry up for litigation. That gives you a 3 to 5 day turnaround, and it's almost $900. If you have a group of unpublished works, there are some applications where you can file those unpublished works all together and save some money. You can file up to 750 photographs in one application, or 10 individual works, and that's fairly recent, the 10 individual works. And the requirement is author and claimant be the same and the type of work be the same for all 10 works. So you can't register a motion picture and a literary work in a group application. In order to maintain your rights, you'll register first. If someone does use your work, let's say they take a scan of your website and you've registered that website and you see someone in China has literally mirrored your website on another page. If it's accessible to US consumers and you have the ability to serve that owner, you could sue them in the US. You could get an injunction. If there were actual goods that were out there, you could impound them and get them destroyed. You could get your actual damages. The the profits earned by the infringer for any sales, or you could get statutory damages. In many cases, statutory damages will be more than your actual damages if you find the infringement quick enough. Statutory damages can be anything from $200 to $150,000. So it's quite a large realm, and much of that depends on whether the infringement is innocent or willful. In order to get statutory damages, it's important that you have registered your copyright prior to commencing the infringement and no later than 3 months after publication or 1 month after learning of the infringement. For an unpublished work, you must sue prior to the infringement. You must register prior to the infringement occurring. You only have 3 years to bring an action for infringement. So it's important to keep track and remember that 3-year period because you can't sue after that expires. You may also be able to get attorney's fees, but that's at the court's discretion and usually occurs when there's willful infringement by the defendant. If you think somebody has infringed your copyright and copied something you have done, consult with legal counsel. The standard for infringement is quite different than with trademarks, where it's, is there a likelihood of confusion between these marks? With copyright, the issue is there a substantial similarity and has there been copying? If Laura goes and takes a picture of the mountains and I go out the next day and the lighting is the same and the clouds are the same and I take the exact same picture, and those two pictures, when placed side by side, look identical, we both own a copyright in those images because we both took the effort to go out and take those pictures. It's an infringement, however, if I take a photo or copy Laura's picture. And that's really all I've got for copyright today. To go in any more depth, we'd be here for a couple of weeks. Laura, do you have any questions?
Let me unmute. No, I don't. Actually, as my questions came up, you answered them.
Yeah,
so
we're starting to read each other's mind.
Exactly, but that was very, very helpful. Let's see. It looks like we have a question. So we've got someone typing in. One of our guests asked, can you explain the 30% rule?
There is no such thing. That is out in the world. There is no black line that if you use a certain percentage of somebody else's work, you are fine. It simply doesn't exist. If you use one measure of someone else's music, but that is the crux of their entire song, and it is easily recognizable when you hear that one measure, that's copyright infringement. And it's certainly significantly less than 30%. There's no strict percentage rules.
That's interesting. And let's see, we'll just give it a minute and see if we have any other questions coming up.
Absolutely. There's some interesting cases in the last few years on the transformative piece to using someone else's work. If anybody remembers the show Three's Company, another producer decided to make a musical. Same characters, same plot line, and the only difference was a new storyline, but with same characters and music. And the court found that because it was a musical, it was fair use and transformative.
Interesting.
So even though it was commercial use, the transformative nature was important. There are plenty of cases that go the other way as well. So again, you'd have to consult with an attorney before you make use of anybody's work. And there's also the underlying rights of publicity and rights of privacy that people have that are kind of secondary issues to a copyright issue. You might be fine on copyright law, but you might be accidentally using someone else's name and absconding with their right to publicity. My rule of thumb is always ask for permission. If you want to use someone else's work, they're usually pretty delighted to give that right. And there are mandatory license rights for musical and sound recordings, and that's all done through the Copyright Office and through licensing groups like ASCAP and BMI. I had a nonprofit come to me recently and say, hey, we'd like to use less than 30 seconds on a loop of a famous song for our nonprofit video for our end of year celebration. And as long as they use that privately, it will be a very small license fee through ASCAP. And in this case, Sony, because there are multiple producers. But if they were going to put it on social media, it would be an extremely higher license fee. So think about how you're planning to use something before you figure out who do you ask. If it's a registered copyright work, you can go to the Copyright Office and the permissions information will be there. Or you can look online, Google the work and see who owns the rights and simply email them. It's the best course of action and the least expensive when it comes down to infringements.
Well, it doesn't look like we have any more questions, but as always, thank you so much, Judith. This has been incredibly informative, and I think you were talking this morning, and your previous webinars have received over 400 hits. So we're getting some really good information out there to small businesses, and I really appreciate you participating with us.
Absolutely.
So happy holidays, happy Thanksgiving to everyone. And we'll pick back up with, I think, our last one with Judith in 2 weeks.
All right. And the topic is yet to be determined. So everyone will have to kind of stay on the Grand Junction Business Incubator site so they can get further information on our final episode.
Thanks so much, Judith. Talk to you soon.
All right. Take care, everybody. Happy holiday.